Second case on the calendar is in re Ida Staniel.
May it please the court, Wendell Robinson on behalf of Mr. Daniels. Your Honors, what I would like to do is to go right to the issue I think that the hearing committee had with respect to Mr. Daniels. They only found that he qualified or met one of the Roundtree criteria, and that was the competence to resume the practice of law. Their primary concern throughout their recommendations is that he wasn't clear about his tax obligations. We believe that the committee not only had the testimony of Mr. Daniels, but he submitted documents from the Internal Revenue Service indicating exactly what was his tax liability. And that
no, Mr. Robinson, those documents really didn't, right? I mean, I take it that you're referring to the March 2012 notice of refund and the November 5th, 2010 installment plan letter. Is that correct?
No, that's correct, Your Honor.
Okay, so let's look at the notice of the refund, which is one page and lists some numbers, says there was an overpayment for 2011 and then applied tax owed for 2001 and 2002 and 2008, and then it says your refund. If you haven't already received a refund check for $376.10, you should receive it within 2 to 3 weeks, as long as you don't owe other tax or debt we're required to collect.
Well, that's correct.
Well, that's the big question. I mean, that's one of the questions, right? We don't even know if you ever received that money. We don't know whether that as long as phrase applies, right? But more fundamentally, Mr. Robinson, there's nothing in the record that says that your client came clean with the IRS such that they could calculate what was owed, due and owing, or whether or not he had made them whole.
Well, his testimony, Your Honor, in addition to the letter...
Why should we rely on your client's testimony when he has a history of misrepresentation before the board, before the ad hoc committee and the board, right? I mean, he lied to the IRS in 2003, which is precisely why he was disciplined in this case. So how do we know? There is nothing in the record that shows that he came forward to the IRS and came clean to them about what his income was over the years, right?
Well, Your Honor, if you take a look at what Bar Counsel indicated is that my client had a prior matter with the Internal Revenue Service, and the Bar Counsel obtained all of his tax records. Mr. Daniels testified...
Okay, Mr. Daniels is before the ad hoc committee in 2014 applying for reinstatement. The burden is on him to put before that committee the fact that he has made amends and been clean. And regardless of what was before the committee in 2008, in 2008 your client didn't appear. He chose to remain in North Carolina so that he wouldn't have to testify. If he had been in D.C., he would have been called to testify, but he chose to remain out of range of disciplinary counsel. And so no records regarding his liabilities were presented in the 2008 proceeding.
Well, Your Honor, all I can tell the court is that with respect to the letter that you're referencing that we have, which is Exhibits 12 to 14, what he testified to was, and I think that letter indicates, response to his call to the Internal Revenue Service to say, I want to resolve my tax liability.
You're talking about the 2003 letter?
No, Your Honor. I'm talking about the letter of November 5th, 2010 that you referenced.
Okay, which is incomplete, by the way. Right? If you look at the bottom, what's marked as page 13, there's a number 7. You will provide a current financial statement when we, and then you go to page 14, and it's talking about something else.
Well, I provided the 4
There's no complete letter in any of the record materials that we have.
Well,
it's reproduced a number of times with 3 pages.
Well, that's correct, Your Honor. Those are the 3 pages that my client said the Internal Revenue Service sent to him to confirm his conversation with them that he wanted to take care of all of his tax
So
liabilities.
he didn't have any curiosity as to what it is you will provide a current financial statement when we...
Well, no, Your Honor. My point to the court is that when he went to the Internal Revenue Service to take care of his entire tax liability, this letter is a response to from the Internal Revenue Service, which indicated the tax year...
Right, but wait, you're still missing my fundamental point. The second paragraph of that letter, which is incomplete, says, based on your payment proposal. So the IRS is going on information that he has given them, but he has lied to them before, right? In 2003, he said, I don't have any personal and business accounts. Meanwhile, he was using 2 IOLTA accounts as personal and business accounts and had deposited hundreds of thousands of dollars in them to conceal them from the IRS. So the fact that he then, in 2010, goes to the IRS and says, once again, I'd like to try and settle things with you. Here's my proposed payment plan. Why should we trust that any information that he has given them is accurate? We don't even know what he told them. That's not in the record before us. There's no way for us to evaluate that.
Well, he testified, Your Honor, and I understand what the court's position is. He testified that after he met with them, they gave him a payment plan that he adhered to. There was never any...
For what years of back liability?
2000, 2001, 2002, and 2008.
Well, these are for discrete years. They gave him a payment plan.
Correct.
And he says he made the payments, and they even acknowledged he made the payments because they gave him some money back, and so forth.
Yes, Your Honor.
But he testified before. The committee relied on partly, maybe significantly, the fact that he testified that he had tax arrearages going back to the 90s. How do we know? What in the record tells us that he had come clean with the IRS, that the IRS was satisfied and all of those arrearages had been made up and paid?
Well, he testified that whenever he went to the IRS in terms of making the payment arrangement, that he wanted to clarify his total tax liability. Now, what he said was...
Well, yeah, that's what he wanted to do, and there's a certain reason this Judge Easterly is suggested for being skeptical about his testimony, and the committee was skeptical about his testimony. But what is there in the record that gives us assurance, could have given the committee assurance, that his liabilities going back into the 90s, as well as going forward, had all been settled with the IRS and were all basically erased from the books? The IRS was prepared to give him a clean bill of health. You no longer owe us any money. How do we know that's the case?
Well, because, Your Honor, I think if you look at the testimony, the issues that Bar Counsel raised up was that there was an effort that they thought to compromise his tax liability, and that he had tried to get a reduction in the tax liability. He testified, indeed, he had attempted to do that, but it was rejected, and he said, I paid the entire tax liability.
But I have tried to conceal income from the IRS in the past. I then go to the IRS in 2010 and I tell the IRS, look, I've previously tried to withhold income from you, but now I'm telling you I have $500,000 of undisclosed income, right?
Yes,
We
sir.
don't even know what he told the IRS in this case, but in my hypothetical, I tell you, I have $500,000 of undisclosed income. Now please tax me on that income. The IRS says, sure, here's your installment plan. But what if, in fact, I actually have $1 million of undisclosed income, right? Why do you trust me? I've lied to you before. And how do we know what he actually had? He doesn't put anything before the ad hoc committee except this one piece of paper, right, saying, I'm due a refund unless you actually still owe more taxes, and this incomplete installment plan.
Well, Your Honor, if you take a look at, he'd sent a letter to the Internal Revenue Service sort of laying out that he was deceptive.
Now, let me get started on those letters, because there's part of me that thinks that these petitions for reinstatement were a big waste of everybody's time. He came back in 2013, he petitioned for reinstatement. It was made quite clear to him that he needed to put more information about his tax liabilities before the ad hoc committee. Apparently, he had put some sort of redacted documents before the committee in 2013, and he promised to unredact them. I don't know what happened with that, and those documents aren't before the 2014 committee and therefore aren't part of the record in this case. But then he comes before the committee in 2014 and he says the reason why I rescinded my petition for reinstatement in 2013 was to write these letters to the IRS, right? One letter to the commissioner of the IRS and one letter to this caseworker. Now, does the commissioner, in your knowledge, do casework?
Not in my knowledge.
No.
Yes, not.
Okay, and then this one caseworker, Ms. Stevens, did he have any information that she still worked at the IRS? The last time he corresponded with her was in 2003 when he lied to her, right?
That's correct, Your Honor.
Okay, did he know that she still worked there 10 years later?
I'm not sure, Your Honor, because under advice of counsel, what I told him was what we need to do is to come clean with the IRS from
Right,
the
and
top
so
all the
this
way
was your
down.
idea of him coming clean, is writing a letter to a caseworker that you don't know who works there anymore, and he gets a certified receipt saying that the letter has been received by some person named Nicholas.
Well, Your Honor, the point of the matter is that he had to come clean with the Internal Revenue Service.
How did this letter make him come clean? It doesn't have his social security number on it, it doesn't have his address, it doesn't have his date of birth. It just has his name and it says, I need to, achieve redemption or something.
he
It doesn't
testified-
talk about numbers.
It-
How does this give the IRS information that it needs?
Well, Your Honor, it wasn't intended to give the Internal Revenue Service information needed. He testified it with his letter. He also testified he wanted to come clean and recognize that what he did was wrong and that he made some misstatements to the Internal Revenue Service. Now, with respect to whether or not he went to the Internal Revenue Service and said, I have $500,000 that should be taxed on it, what happened was, as the court probably knows, is that he had indicated that he took money from his personal account and put it into the escrow account to preclude the Internal Revenue Service from seizing on that money.
Okay,
That money
let's
was-
talk about that, because
that-
the Court of Appeals found that he put the money in the IOLTA accounts to conceal it from the IRS. And yet, when you look at his 2008 affidavit in lieu of testimony, and you look at his testimony in 2013 before the hearing, and you look at his testimony in 2014, he is not acknowledging that he concealed funds. In fact, in 2013, he is quite express that he said, I declared all income to the IRS. I was only moving it to the IOLTA accounts to, as you say, prevent it from seizure. Right? So how can we square that with this court's determination in 2011 that he was actually concealing funds, that it wasn't just an attempt to maintain control over these funds so that he could pay it back on his own schedule, but that he was actually hiding income from the IRS?
Well, Your Honor, I think
Is that acceptance of responsibility if he's still making that argument in 2013 and 2014?
he testified that he did that, and he indicated that the sole purpose was for him to prevent the IRS from seizing
Is that
those
acceptance of responsibility if he is
Well-
testifying to that in 2013 and 2014?
He testified that he accepted that he did wrong whenever
I think
he...
the answer is no.
Well, Your Honor, I'm just telling the court with respect to what he indicated in his testimony, that he accepted that he was dishonest with the Internal Revenue Service, that he inappropriately took money from his private account and put it into the IOTA account to prevent seizure. Now, with respect to whether or not we knew exactly how much money was owed, well, his IOTA accounts were seized, the subpoena was given there, so we know exactly how much money he was seeking to hide from the Internal Revenue Service. I mean, bar counsel has had that for a substantial period of time. So whenever he went to the Internal Revenue Service, Your Honor, I cannot tell you exactly whether or not he went there and said, I'm hiding assets. His testimony is that I came clean and I told them I wanted to make an arrangement with the IRS to clear up all my tax
Are
liabilities.
you talking about 2010 or 2013?
Well, I'm talking about the letter that was dated 2010, but when
Okay,
he
where is it that he came clean before that installment plan was worked out?
Well, Your Honor, I can only go by his testimony that when he went to the Internal Revenue Service, he wanted to make sure that he got all of his tax liabilities together so that he could take care of them.
And that's exactly what he was trying to do in 2003.
But, Your Honor, what we're talking about is, if Your Honor wants to look at what he did in the past, there's no way I can say that was good. When he seeks reinstatement, he has to be able to demonstrate to the hearing committee in this court that based on what I did in the past, and what bar counsel likes to say is that you got to rehabilitate yourself from the ground up. That's what he did. He can't unring the bell of what he did in the past. All he can tell the committee is that what I did to try to establish what my tax liability was go to the IRS, determine what my tax liability is, make arrangements to pay it, and keep that agreement. And that's what he did. Now, if we take a look at the past and keep juxtaposing and say, yeah,
The
but you said...
2010 installment agreement was negotiated while his disciplinary matter was still on appeal to this court,
My understanding, Your
right?
Honor...
This court didn't issue its decision until 2011.
That's correct, Your Honor.
Right? And his position in the disciplinary matter was that he had done nothing wrong.
Well, Your Honor, I'm talking about the hearing that
Right?
we
If
had
we look at
in-
his 2008 affidavit in lieu of testimony.
I understand that, Your Honor. I understand that's what happened in lieu of testimony he failed to appear. The point that I'm trying to make to the court here is that he understands what he did in the past was wrong.
But why do we know that he understood that in 2010 when he negotiated the installment agreement? Why do we know that 2010 was not just another example of the behavior that we saw in 2003, particularly since this court had not issued its decision in 2011 saying, yeah, we are finding that you committed that you violated certain disciplinary rules. In fact, we're finding that you violated 8.4 twice.
Because, Your Honor, when he came to the committee, even if you go from 2010 to the front, he's consistently doing and taking steps.
He wasn't before the committee in 2010. He didn't come before the committee until 2013.
Your Honor, my point...
So I just want to make sure that we've got the time frame right. The time frame is he sets up these IOLTA accounts. He incurs tax problems. He starts hiding funds in these IOLTA accounts in 2000. In 2003, he says he wants to resolve his tax problems, and he lies to the IRS and says that the IOLTA accounts don't exist, essentially. And then he's hiding money, according to this court's decision, in the IOLTA accounts through 2005. Bar counsel then catches up with him in 2007. There's a hearing in 2008. This court affirms in 2011. Meanwhile, in 2010, he's trying to negotiate another settlement, right? He doesn't express any remorse for anything that he has done until 2013. And even in that testimony before the hearing, the ad hoc committee hearing, in that petition for reinstatement, he is denying that he was hiding funds. He is asserting that he has that he declared all of his income to the IRS, and he is saying that he merely used the IOLTA accounts because he thought that that was a way of preventing seizure of funds from the IRS and allowing him to dispense the money in a more manageable way so that he could maintain, pay rent or whatever, and satisfy his obligations. But the Court of Appeals in 2011 had already said, you were hiding money. You were concealing. The word conceal is used 5 times in that decision.
Your Honor, there's no way that my client can erase what happened in the past. All he can attempt to do is to make sure that prospectively he does what he's supposed to do to ensure that what he did in the past doesn't reoccur. At his July 2014 hearing, Your Honor, he clearly testified about the wrongdoings that he did. He clearly testified of what steps that he had taken to take care of his tax liabilities.
Let me just ask you a question. At the July 2014 hearing, you ask your client whether he put the money in the IOLTA accounts while negotiating with the IRS. And your client says yes. But he didn't put the money in the accounts while he was negotiating with the IRS. He started putting the money into the accounts in 2000. He put the money into the accounts through 2005. He negotiated with the IRS for some time period between 2001 and 2003, at which point he lied to them. So that question in and of itself seems designed to elicit misleading testimony from your client.
Your Honor, my client testified truthfully, and the court indicated there was no testimony that I recall, at least from cross-examination, that went to where the court went. He testified truthfully that what he did was wrong. He testified about
He was
it
asked
during-
repeatedly, were you trying to conceal funds? And he doesn't answer. He says, I was trying to prevent seizure of those funds, yes.
And
Can I ask
look,
a question, Mr. Daniel?
Robinson, Your Honor, I'm sorry.
Mr. Robinson, I'm sorry. Let's assume for the sake of argument that at the end of the hearing, the committee had said, we are satisfied that your testimony, Mr. Daniels, today is honest. We're further satisfied that that you have stopped your former behavior, and at least for several years now, you have no longer in any way, shape, or form tended to mask income from the IRS or from anybody else entitled to know it. In other words, your past practices were satisfied, have been erased. Your character is now impeccable, unimpeachable in terms of being honest and candid with the tax authorities. Still, we want to know a simple answer to a simple question. Do you still owe the IRS money for any tax arrearages going back into the 90s and going forward? And we would like you to document that to us by something from the IRS. Would that have been fair for the committee to ask that question?
It would have.
And isn't it exactly in effect what they're asking? We want proof, not just your testimony, that you no longer owe the U.S. government any money in back taxes.
Yes, and he testified that...
I'm not talking, we don't want
yes,
testimony.
Yeah.
We want some documentary proof from the Internal Revenue Service that he is clean with them for the last 15 years.
Well, Your Honor, his testimony... Yeah, I'm sorry, Your Honor. The
And
documentation...
The answer is he produced no document.
Well,
Is it impossible for him to produce that document, that the IRS, whatever his past shenanigans, is satisfied that he doesn't owe the government any money?
Your Honor, his position is he presented that documentation.
He presented something about some discrete years as to which they entered into an agreement with him.
Your Honor, his testimony was that he went there to cover all the years of his tax liability, and this letter was in response to that for the actual years that remained.
That's his testimony. And what prevented him, maybe it's impossible, from getting something from somebody in the Internal Revenue Service to say, his testimony is correct. He is quit with us. He is whole. He has made himself whole with us. He owes the government no money.
Your Honor, in response to that specific question, you're correct. He could have done that. He thought that with respect to the response that the Internal Revenue Service sent to him after he sat down and said, I want to clear up all the years of my past tax liabilities, they then determined that the years for his tax liability were only 4 years. In the years of 2000.
If I could, I'm going to bring this to a close soon because we're over time, but I guess what I would say is, the question for me is this. There's evidence, and I don't remember all the years and all the specifics, but there's evidence that going back into the 1990s, there's evidence that Mr. Daniel did not pay taxes that he owed because he was concealing income back in those years. And I guess I would think that what one would want to see, if one were the hearing committee, is documentary evidence that the IRS knew about that withholding of taxes or that failure to pay taxes for those years, and documentary evidence that subsequently Mr. Daniel paid taxes owed for those years to the satisfaction of the IRS. Is there some reason, that I think is my understanding, and I'll confirm this with Bar Counsel, That is my understanding of what was missing here. Do you agree that that's what was missing here?
I agree that's what everyone is alleging is missing, yes, Your Honor.
Okay.
And I
Could something
understand.
have been done? Are you saying that people are under some sort of misapprehension when they focus on that?
No, Your Honor, I think that is a fair question, and I think what Mr. Daniels' position is, I've done that, and I went...
Well, that's his position,
And-
but what documentation is there that the IRS was aware that taxes by Mr. Daniel were owing for those years, not 2008, not subsequent years, but those years, and that the issue had been properly resolved? That issue had been properly resolved. Because I think what the hearing committee felt was that, well, these documents show that you have satisfied tax obligations to the IRS for certain years, for subsequent years, I forget what they were, 2008 or what have you, 2003, whatever. But they don't show us that you've rectified the problem that led to your getting in trouble with the bar and being suspended, namely the fact that you withheld taxes for those years in the 90s. And you can't draw the inference that the IRS said they were satisfied in 2010 or 11 or what have you, because we don't know that we don't see any indication that the IRS knew taxes were withheld in those earlier years. How do you respond to that? That's my simplistic understanding of the problem.
If I could just go back to the letter of November 5, 2010, the first year that they have in there is year 2000. My client's position is that all of that was discussed in the meeting he had with the IRS.
Well, that's his position, but tell me how the hearing committee is concerned that we don't see any documentation that the amounts owed for the earlier years were identified to the IRS, were determined, and were paid.
Yeah. The only thing we can say with respect to that, Your Honors, is that the assumption would be, incorrect or what have you, that when they sat down and met, and when they looked at his tax liability, the first year that they found that he had outstanding taxes was the year 2000.
That only works if the IRS is shown to have known, even then it's based on inference, but the inference can only be argued if it is shown that the IRS knew about the concealment of income and how much income was concealed for the prior years.
Well, I think that's correct, Your Honor, but I think if you take a look at what the judge had indicated with respect to the notice of refund, the IRS was on notice that he had prior years of tax liabilities because they stated, as the court indicated that, and I quote, "If you haven't already received a refund check for $376.10, you would receive it within 2 weeks as long as you don't owe other tax or debt we're required to collect," end of quote. His testimony was that he received the money and he didn't owe any, and he said he didn't compromise his tax liability. So with respect to what the IRS says here, with respect to starting into those 2 years beginning in 2000, he had indicated to them, without any confirmation, that here's what my tax years or obligations are. You tell me what I owe and I'll pay it. They confirmed it, and the first year that they said that he had a tax liability was 2000.
Okay.
Now, if...
I take your argument. Let us hear from Bar Counsel, and then we'll give you a couple of minutes in rebuttal. Okay.
May it please the Court, Dolores Dorsonville on behalf of the Office of Disciplinary Counsel. I'm joined here today with Disciplinary Counsel Gene Shipp, who's seated at Counselor's table. Disciplinary Counsel supports the Ad Hoc Hearing Committee's report and recommendation denying petitioner's petition for reinstatement. Excuse me. The Hearing Committee correctly determined that the petitioner failed to meet the necessary requirements to demonstrate that he is fit to resume the practice of law.
Can we just focus in on this question of tax deficiencies? And I just have a question about Bar Counsel's answer after Mr. Daniel submitted his petition for reinstatement. He says in his petition for reinstatement, paragraph 3, that after a great struggle, he's resolved all of his tax obligations to the IRS. It's been onerous, but it's a great relief to have accomplished this goal. As of his 2012 tax filing, petitioner is all square with the IRS. And in disciplinary counsel's answer to this paragraph, bar counsel admits the allegations set forth in paragraph 3 with regards to tax years 1999 until the present. For the tax years prior to 1999, bar counsel lacks sufficient knowledge with regard to whether petitioner has resolved his admitted tax deficiencies. And I guess I'm curious to know why bar counsel admitted the allegations set forth in paragraph 3 with regard to tax years from 1999 to present.
Your Honor, that wasn't...
And whether you still admit that, or whether bar counsel's position changed at the hearing.
Your Honor, with regard to question number 3 on the questionnaire, that was an error. Bar counsel does not admit that. What petitioner provided in terms of the installment payment plan demonstrated that for certain tax years, he did resolve some of his liability. And that's demonstrated by the document that petitioner has put into evidence. However, with regard to his other deficiencies going back to the mid-1990s and forward, we do not have sufficient information to make that statement. But to go back to some of the petitioner's statements here, we know
Well, excuse
that...
me, I'm not sure I understand what you just said.
Mhm.
You're saying that the answer you gave there, which was basically a stipulation, if I understand correctly, was incorrect.
That's correct, Your Honor.
Was the error in giving that answer corrected below, in the proceedings below, by which I mean before the hearing committee?
There is no evidence that that was corrected below, Your Honor.
So Mr. Daniel could rely on that answer as, call it what you will, an admission, a concession, a stipulation by bar counsel, and was not under any obligation to present further evidence with respect to it. Is that right?
That could be, Your Honor. However, we do know, based on the documents that he has provided, that he has not demonstrated by clear and convincing evidence that he has resolved his tax deficiencies for the years going back to the mid-1990s.
So that gets to what I wanted to ask you to clarify for me. What tax years are actually in question here, and what documentation or other proof do you think was lacking? What do you think what is it that the hearing committee wanted that they did not get, and for what years? If we were to issue an order saying, all right, Mr. Daniel, not that we're going to do this, we don't issue orders like this, but if the hearing committee were to issue an order saying, all right, Mr. Daniel, we're going to give you one more chance, give us A, B, and C if you want to satisfy us. What are A, B, and C?
A, B, and C certainly would be tax documents going back to the dates that the petitioner testified with regard to when his tax problems first started.
What do you mean tax documents? Can you be a little bit more specific?
Sure.
Because at the hearing in 2013, just to give background for my question, there were more tax documents put into that hearing. It's not clear what they were. They were redacted, and as I mentioned earlier, Mr. Daniel said that he would submit them unredacted to the ad hoc committee, which I don't have any reason to know happened. But he also said at the 2013 hearing that he just doesn't have tax records and that he couldn't do a 10-year audit. And bar counsel at that point said at the 2013 hearing, which is an exhibit before us, that they don't want tax returns.
Specifically, in terms of the years, we're talking about going back to at least 1995. We're talking about perhaps a tax transcript, documents that would indicate the income that petitioner claimed to the IRS.
I'm sorry, excuse my ignorance, but what's a tax transcript?
Tax transcript is Basically, it just sets forth what a person's liabilities are, what their taxes that are owed. It's pretty much like a summary,
Who prepares that?
the IRS.
When do they prepare it?
I'm sorry?
When do they prepare it?
I don't know when they prepared it. We're simply saying that,
It's something that would be prepared by
It-
by IRS at the taxpayer's request? Is it in the nature of like, please audit me and
I don't
prepare
know
this
if it's
tax transcript?
yeah,
Or,
I don't know if it's in the nature of requesting an audit, but it at least provides summary information as to certain tax years. So it would at least set forth what the income that was claimed, what the liabilities are, and what the taxes are owed. I mean, this general basic information is information that unfortunately we have not been able to receive from the petitioner. So, I mean, that's pertinent and relevant, certainly because this goes back to the court's directive, which was in 2011, when the court put the petitioner on notice and said, for purposes of reinstatement, should you, and when and if you do seek reinstatement to this bar, this is what we want to see. We want to see that you have resolved your outstanding tax deficiencies, and we want to see that you've actually righted your wrongs.
I don't know that we were so prescriptive. I mean, we didn't order him to do that as a condition of reinstatement. We just said that we had no doubt if and when he sought reinstatement, that his status with the IRS would be a relevant consideration.
You're correct, Your Honor. It is absolutely a relevant consideration. And here we are in 2016, and petitioner has known about this since 2011. And in 2016, he has still failed to produce any meaningful or relevant tax documents.
With respect to what years now, again?
With respect to going back to the mid-1990s, to the time of the hearing. What he's produced are the two documents, the installment activity payment document that you had referenced earlier, and a refund from the IRS for the tax year 2012.
And he actually produced those after the hearing. So Bar Counsel didn't have those when Bar Counsel submitted its answer to his petition.
That's correct. This was all submitted.
Or were those submitted in 2013 as well?
That I am not aware of. I don't recall it off the top of my head, unfortunately. I do know that after the 2014 hearing, these are the documents that were submitted. And the first,
Right, the only tax document he submitted at the hearing was his letter to the Commissioner of the IRS in 2013.
okay, then these were submitted in 2014 at that hearing.
Before 2000...
No, these were submitted after the hearing. After the hearing closed in August, these documents were submitted. At the hearing, the only document he submitted as an exhibit regarding his tax liabilities, although it sheds no light on it, is his letter to the Commissioner of the IRS.
And that letter, if I may talk about that act of redemption that he mentioned earlier, that letter does not set forth much of anything in terms of how he interacted with the IRS for that 10-year period of time from 2003 up until 2013. What we know is in 2012, or the tax year 2011 going into 2012, he entered into a payment arrangement with the IRS. However, we don't have basic information to determine or evaluate what representations he made to the IRS when it is that he entered into this agreement. And unfortunately, he comes clean in 2013, but he does that months before he files this petition for reinstatement. And then, of course, after he's already received some of the benefit because he's resolved, at least at that point, some of his outstanding tax liability.
Before 2013, is there any documentary evidence, or any evidence, that the IRS was aware of the concealment of income in the 1990s?
No.
And so there was no documentary evidence that Mr. Daniel informed the IRS, and the IRS was not aware of the Bar Counsel proceedings, I take it, the disciplinary proceedings?
That's correct. And so, going back to that.
So we have, and even after 2013, we have no specific documentary evidence that the IRS was aware.
That's correct, because we have no evidence that,
So I
we know
take it, as a result, there's no documentary evidence that the proper amount of income tax was paid for those years in the 1990s.
That's correct. So, Your Honor, we have no corroboration for several of the unsubstantiated assertions that petitioner has made. And he's done this all
And it
throughout.
ought to be possible to pay, if those things had been done, if Mr. Daniels had, at any point, gone to the IRS and said, I need to get this resolved in a proper way, there ought to be some documents, some correspondence, some forms filled out, indicating some agreements, indicating that the IRS had been given the information and that payments had been made or were being made.
Absolutely. And if the petitioner was not in possession of those documents, it's Bar Counsel's position that he's the only person, or he's the person in the best position to obtain those documents. Because he's failed to produce anything meaningful throughout these proceedings, really...
Tell me, as a procedural matter, tell me how this works. Did Bar Counsel, excuse me, I'm sorry, did Bar Counsel request, I realize the burden's on Mr. Daniel to come forward with, I'm just wondering procedurally how this all worked. Did Bar Counsel request documents with the kind of specificity I have just attempted to articulate of Mr. Daniel?
Yes, Bar Counsel did, by way of subpoena. Bar Counsel...
What kind of response did you get?
The response was petitioner was not in possession of those documents.
Is that subpoena in the record?
That subpoena is... I believe it is in the record, Your Honor, at Bar Counsel's Exhibit 12. At Bar Counsel's Exhibit 12.
Did Mr. Daniel or his counsel represent to the hearing committee that, with specificity, that he had provided that information I've just been talking about to the hearing committee and had made payments for those years in the 1990s?
He is not. The information that the petitioner has provided, as you could see by way of what he's testified to, are these general broad statements. He stated that he's all square with the IRS.
And I take it no one has made a formal information request to the IRS for documents in its possession relating to this area that I've just identified.
We have not, Your Honor, with the privacy laws.
To your knowledge, you don't know if Mr.
To my knowledge,
Daniel has. Okay.
So
I'm
you're
certain we have not.
saying, you referred to a tax transcript or something before. For each of the years from, say, 1995 up to 2000, it wouldn't be possible for the IRS to express a judgment in some kind of document that indicates their knowledge of his income for those years and what taxes were paid for each of those years. And if he were to come forward with documents for each of those, say, 5 years, showing that in the view of the IRS, he owed nothing anymore. He had made any back payments he owed, or he had had adequate money withheld. To their knowledge, he is not concealing any income. They are satisfied that he has no remaining tax liability for the 5 years. Would that, in your view, be sufficient to justify his reinstatement?
No, disciplinary counsel's position is that, given the petitioner's history, past history of dishonesty, that very well may not be sufficient.
Well, what more would be required? How could he prove, if IRS is satisfied, after we assume they've made an investigation, that there's no longer concealment for those 5 years? Let's talk about those 5 years. And on top of that, he testifies there was no concealment for those 5 years, and IRS, I've satisfied them that there was no concealment. What more does he have to demonstrate?
Well, given his past representations to the IRS, I mean, we're not in a position where we're going to necessarily take the petitioner at his word. I mean, other corroborating evidence and documents to support whatever it is, representations that he's making to the IRS would be important. That would certainly be important for us to evaluate the honesty, you know, if he is engaged in additional dishonesty, if there are issues with other additional assets that he's not claiming. I mean, what I'm saying is petitioner has failed to paint a complete picture in terms of what his overall tax status looks like, what his overall income, what his liabilities were, what the deficiencies were.
Okay, but, I mean, is it within Bar Counsel's purview to examine sort of what his current tax compliance is? I thought that really Bar Counsel was interested in him making sure that he had made everything right that led to his discipline in this case. And that was, you know, the tax difficulties that led him to conceal income in the IOLTA accounts and
Right.
then led him to lie to the IRS and use these IOLTA accounts that he wouldn't have had access to unless he were a lawyer, right?
Right, that's absolutely true.
So we are looking at a discrete period of time, correct?
That's correct, Your
Can you
Honor.
tell us what discrete period of time you want? Earlier you said 1995.
Right,
1995 to when?
the petitioner has testified that the period where this tax problem initiated was 1995, and we know going into at least 2003, when he was improperly using...
Well, the Court of Appeals opinion says that he was using the IOLTA accounts, at least one of them, through November of 2005.
I misspoke, you are correct.
So
At least
what if
till
we said
2005.
between 1995 and 2005?
That's correct, Your Honor.
Or I guess that would be tax year 2006. I mean, he would file a return in 2006 for 2005.
That's correct, Your Honor.
I'll get myself all confused about looking backwards and forwards, but at least we understand the time frame that we're interested in. Okay, and then getting very specific about the information that Bar Counsel thinks is required. You've mentioned this tax transcript, which, as I understand it, you wouldn't get a tax transcript for each year. You could get a tax transcript from the IRS for this decade period. Is that correct?
Well, what we know is that it's the petitioner's burden. So he could have requested a tax transcript for that relevant time period.
For that relevant time period, but then
And
in
what would
addition...
show? What would show the tax transcript?
I mean, it would at least show us the representations he's made to the IRS.
You would see the money that he had declared
That's
and the
correct.
taxes that he had paid,
That's-
right? So that would be some information. But in addition to that, what I hear you saying is that you need one other category of documentation, which is some showing that he has actually communicated to the IRS in a meaningful way, not just a letter to the commissioner and not just a letter to someone he had a phone conversation with 10 years ago, but had communicated with the IRS in a meaningful way to say, look, from the 1990s through 2005, I was misusing and concealing funds in these IOLTA accounts. So now tell me, did I pay my taxes properly for that period of time?
Correct, and that's not what we have here. What we have here is the petitioner coming clean in 2013. So a decade later, he's come forward in an attempt to provide a sufficient record for this court for purposes of reinstatement by saying, now this is my act of redemption. Now I'm going to demonstrate.
You're saying that's rather late. I mean, to be fair to disciplinary counsel, what I hear you saying, and maybe it's worth making this explicit, is that even if Mr. Daniel provided all the documentation that could be provided, and even if it showed that he had come clean with the IRS and paid what he had to pay and it's all over with, you would still have concerns about, I'll put it, his candor in these proceedings and so forth, and the belatedness of the cooperation and so forth. That might or would cause disciplinary counsel still to oppose reinstatement. Is that a fair statement of your position?
That's a fair
Disciplinary counsel.
That's a fair statement, Your Honor. I mean,
Yeah, but
this,
how would you overcome
the-
that?
well, I mean, this just goes back to the court's initial concern with regard to honesty. And in other cases, you know, like in Ray Courtois, where the petitioner submitted substantial information and substantial evidence that he had communicated with the IRS for a greater period of time in an effort to actually resolve his issues. I mean, here, because the record is so deficient, we don't have any information. So unfortunately, it leaves us in a position where we're not able to properly evaluate what representations that the petitioner has made, and given his history of past dishonesty, it's of concern, certainly for this court, certainly for Office of Disciplinary Counsel, excuse me, and
I'm glad I'm not the only one who's so called
Keep stepping up. Right, and it's for those reasons that we really do have concerns, and we believe that because petitioner at this juncture is still not being straightforward, he's still not coming clean, he's still not providing basic information that would at least give us the opportunity to examine and evaluate what his liabilities were.
Well, there's a difference between saying two things. Well, we have reason to think he's still being deceptive on the one hand, and we're not satisfied that he's given us the necessary documentation that IRS, after diligent investigation, has concluded that he owes no more taxes.
Right, well, we know that he hasn't provided anything meaningful. I mean, the two documents that
Do you agree with my reading of his testimony when he is drawing a distinction between concealing and putting funds in the IOLTA accounts to prevent their seizure, that is dissembling or not, he's not being forthcoming or at least not accepting his responsibility for his wrongdoing?
Absolutely, and I mean, that's one example, but there are...
Well, did the hearing committee find that his testimony was dissembling?
The hearing committee found that the petitioner
Had
did-
not provided sufficient documentation of his tax arrearage. And
That-
I don't think they made a finding that he lied all through these years. He's still lying on the stand before us.
No, they did not, but what they said was it was difficult for them to credit petitioner's statements in terms of his recognition of the seriousness of the misconduct, given the fact that he is unwilling at this juncture to provide basic tax information that would answer...
You're saying they didn't want to put too fine a point on it, but they still think he's dissembling or something.
Well, unfortunately, you know, the hearing committee said that, you know, based on the lack of the complete picture and all the questions that have arisen as a result of some of the statements and unsubstantiated assertions that petitioner has made, it's just left them in a position where they cannot support his petition for reinstatement, and disciplinary counsel also does not support that.
Okay, I think we have your argument.
Thank you, Your
Thank you.
Honors.
Mr. Robinson? So, Mr. Robinson, if I could just put it to you, the way it seems to me, and I'd like you to tell me if I'm misunderstanding or if you disagree. The way it seems to me is that the hearing committee could reasonably say, look, all we're asking for, or one thing we're asking for, that we have every right to ask for, is documentary evidence, which ought to exist, showing that there's been disclosure and resolution with the requisite specificity and completeness of the 1990 to 2000, and pick your year, 2003 or 2005, taxes. There's evidence that there was concealment, there's evidence that there was underpayment. We don't see any documentation, and this is what we want to see, of disclosure, full disclosure to the IRS, and full satisfactory resolution of any taxes. And with specificity, not some inference from a later document. We want those documents. What I understand a key portion of the hearing committee's decision to be is essentially, that's what you should have produced, that's what you did not produce. It goes to the heart of the issue that got you disbarred to begin with, and that's a major reason, if not the only reason, but certainly a major reason why we are not prepared to recommend your reinstatement. Do I understand that correctly, and do you have a response to that?
I have a response, and I think the court is correct. That is what the committee stated. I think what happened was, as Judge Easterly stated, that the two documents that we submitted came after the hearing because...
Let's assume I agree, for the sake of argument, that those two documents do not cut it,
Do not what, Your Honor?
are not sufficient to satisfy, to resolve the issue of adequate disclosure and to the IRS and adequate payment of taxes with respect to those earlier years going back to 1996 or whatever. Let's assume, so forget about saying, well, we gave them these two documents, which you can infer satisfied everything. There's more. I mean, that seems to be the crux of the issue, doesn't it?
It does, Your Honor, but during the hearing, the question solely was, had you satisfied your full tax liability with the Internal Revenue Service? He said he did. He said he met with the Internal Revenue Service. We kept the record open so that we could present the documentation that he indeed had
That's
met.
not exactly his testimony. How much were these deficiencies? What was the amount? Do you recall? I don't have any specific recollection of these deficiencies. They accumulated year over year with penalties. So your tax deficiencies, you would say, were larger than $3,000? Yes, they were. Were they larger than $20,000? I would think maybe not.
Yeah,
He
Your Honor,
didn't
I'm sorry.
know. He couldn't say.
That's correct, Your Honor, but I think the point that is being made here is that what he testified to and what we kept the record open for was to present to the committee documentation that he had gone to the Internal Revenue Service.
Because the committee
which-
was specifically asking for that. You said earlier, now you've satisfied the IRS, you've paid in full all those deficiencies. Yes. Is there anything in the record you can point to that demonstrates that?
Your Honor, that's my point, that after the hearing was left open so that we could submit the document of the letter November 2010, where he had gone in to determine what is my tax liability. If you look at the refund, it indicates exactly what was his tax liability as of March 19, 2010 for those 3 years. He had satisfied that. So we presented to the committee what they particularly wanted. What is your tax liability for those years? Did you enter into an agreement to payment which we presented, and were they paid?
Those records don't show what his tax liability was for all of those years.
Well, it states that the tax liability on...
It's a particular bill saying, hey, we paid this much for this year and this much for this year and this much for this year, and we think that you get a couple $100 left over. But it's just for 2001, 2002, and 2008, and Bar Council is saying we're interested in 1995 to 2005.
My understanding from my recollection of the hearing that I was there was Bar Council did not request taxes for 1995 forward. What we indicated was this tax liability was fully paid and that the IRS did not have any more outstanding tax liability, hence that's why he got his refund. He
Bar
testified.
Council asked specifically, does this explain anything about the deficiencies in the 1990s? No, the deficiencies from the 1990s aren't on here.
Well, that document had not been presented when Mr. Daniels testified. The documents were presented after he testified, which you referenced, about the 2010 and the refund letter. We presented those documents to show that he had met and he had made arrangements to pay his tax liabilities.
No, they're talking about the installment agreement at that point because it was a Bar Council exhibit.
Well, there's two different ones, Your Honor. What had happened was it was an attempt, I believe, of Mr. Daniels to enter into an installment agreement which would have resulted in a reduction of compromising his tax liability. That was subsequently denied. The IRS denied that one. Then what he enters into is another one in which he agrees to pay. I can't recall, but it's stated in there the total amount that he was supposed to pay. And he paid it, and our position is that he satisfied fully that amount. And he responded after the hearing. There was a CPA, as I recall, that was a member of the committee. And what he wanted was some evidence to show that there was an obligation to pay taxes, and they had been paid. We submitted these two documents as evidence that pursuant to, I think it was the CPA's request, about whether or not that he had paid his taxes for the year 2001, 2, and 8, as he had indicated that he'd gotten the refund from. So in response to your question with respect to whether or not he had that, he was under the impression with respect to his tax liabilities that he had gone to the Internal Revenue Service. He entered into an agreement. I want to be able to pay all of my tax liability. They said, from our records, your tax liability starts at year 2000. I think to presume that the IRS did not go back further is clearly something that we would have to assume that when they sit down with him and said, here's what the agreement is for the years, that it would cover his entire tax liability, considering he had been found to have been secreting assets. Now, I understand what the court's position here is that this letter of 2010 does not indicate exactly whether or not he had been secreting assets, and if he went to the IRS and said, well, that's not my true liability, I owe this amount of money. Well, he testified that he paid his full tax liability and he did not compromise it. Now, Mr. Daniels was very emotional.
And I guess the question is, do we think that it was unreasonable for the ad hoc committee not to credit that testimony alone without sufficient documentation backing it up, corroborating it? And I just can't see what the possible argument is to say that it was unreasonable for the ad hoc committee to want more in light of your client's history of dishonesty, right? Not just, I mean, he hid the funds, first of all. He lied to the IRS, second of all. He continued to hide the funds and then made misrepresentations in an affidavit in lieu of testimony before Bar Council. He had already been admonished in a previous disciplinary proceeding for dishonesty. In light of that, I can't see why it's unreasonable to have the ad hoc committee make a request of your client to prove it. Give us more documentation, and the documentation that you have cited to us today just doesn't.
I understand the court's position. If I could just briefly respond to that. If there's a representation from the ad hoc committee that's not unreasonable, I think they would have to juxtapose that with his testimony today based upon his past. He's not going to be able to outrun his past. What he has to do, and what I think he did, was he took steps when he appeared before that committee and he testified that in light of my past behavior, here's what I have done. I've gone to the IRS, I've met with them.
Counsel, it's just that at the 2013 hearing, it couldn't have been made more clear that his bald assertions that he was square with the IRS weren't going to cut it. And then he rescinded that petition for reinstatement in 2013. And what did he do? He shot off a couple of letters to the commissioner of the IRS and some random staff person at the IRS that he didn't even know if she worked there anymore. And then he came back and petitioned for reinstatement again in 2014. And it couldn't have been made more clear at the hearing in 2014 that the ad hoc committee, a different ad hoc committee, wanted specific information about what he had told the IRS such that they could say with full information that he had satisfied his liabilities. And he has yet to do that. And you know, your continuation of saying that his testimony should be sufficient, I don't think it's unreasonable for the ad hoc committee to reject that. I don't think it was error for the ad hoc committee to reject that. He has to come forward with something else in light of his history of dishonesty.
I understand. The court doesn't have any other questions of me.
Thank you.
Thank you.
The case is submitted. Thank you, counsel.